Hi, I'm Brian Heidelberger, a partner with the law firm of Winston & Strawn in Chicago, and here today with another mini advertising law lesson. Today's law lesson, what we can learn from the Goldiblox versus Beastie Boys battle of the past couple weeks. But first, you might be asking, Brian, where have you been? We haven't seen you for a while. Well, I stopped working out, started eating, and porked up a little bit, and really decided I didn't want to be on camera. That is until I realized an old trick: just jack up the camera and you people won't see my double chin. Problem solved. Take that, P90X and insanity. So what are we talking about today? We're talking about the Goldiblox case. I'm sure you have all seen the video. It was a very cute and clever video whereby a company that makes girls toys that are attempting to motivate girls to become engineers used a Beastie Boys song in a parody sense to advertise its products and services. The Beastie Boys sent a letter of cease and desist, and in a strange turn, Goldiblox promptly sued the Beastie Boys, asking the court to declare that the usage was fair use under the law. Beastie Boys then sent an open letter to them telling them that they thought it was a commercial use and wasn't fair use. Goldiblox ultimately decided to end the suit and change the song. So we'll never know really what a court would hold in this instance, but I thought it was a good time to talk a little bit about parody and what we can learn from this case. So what is the underpinnings of the law here? Well, use of another's work without permission can really only be legal if it's considered a fair use. Now, what is a fair use? Well, the purpose of the use needs to really transform the original work, use it for something new, to say something different, and generally commentary or criticism of the original work, rather than just using it because it'll be easy to get attention, because it's cool or fun or funny. Now, the problem with ads is that the commercial use weighs against it ever being found a legal fair use. That being said, the more commentary or criticism, the more transformative the use is, the more likely it will be deemed a fair use. So the case that we all turn to in looking at this type of situation is a Supreme Court case where Two Live Crew did a parody of the song Pretty Woman by Roy Orbison. They were promptly sued. The Supreme Court heard the case and found that that instance was a fair use. They did so because the song was commentary and criticism on the original song. Notably, however, in the case, the Supreme Court noted that commercials or advertisements would be entitled to less protection under the fair use doctrine. We also should realize that in that case, what we were talking about was not an ad, but a song, which is highly protected under the First Amendment, whereas commercials and ads are a little less protected under the First Amendment. Now, their cases in this area are a little bit all over the board. There are some cases that have found that an ad can be a fair use when it's a parody. Naked Gun 33 and a Third were sued by Annie Leibovitz when they mocked her picture of Demi Moore on the cover of Vanity Fair. In that case, the court again held that while it was a commercial use, and so it was taken down a notch in terms of protectability, ultimately the court held that it was a fair use given the parody nature of the usage. Now, I think we should realize that in that situation, what we were talking about is a movie poster. Again, a product which is highly protectable under the First Amendment. We all should realize that this was a significant parody, and that's probably what turned the tide. Unfortunately, there are a number of cases, more often than not, where the courts have held that an advertisement which is a parody is not legally protectable. For example, Miller Brewing got sued when they used a parody of a Fat Boys song using Joe Piscopo. In addition, Honda got sued when they purportedly used a parody of the James Bond, and the movie makers of Moscow on the Hudson got sued when they used a parody of a picture found on the cover of the New Yorker magazine. In each of those cases, what the court really held was, first, that it wasn't really transformative in the sense of the ad itself wasn't commentary or criticism of the original copyrighted work. They were just using it to get attention. And number two, they held that the commercial nature, the fact that it was an advertisement, really held against a finding of a fair use. So if we look at all those cases, who would have won the Goldiblox case? Well, I'm not going to step into that quagmire. There are tons of legal pundits out there who have given their opinion. Nobody knows. The area is extremely gray, and how a judge would have come down is very unclear. So, why am I talking to you? What can we learn from the Goldiblox situation? Well, I think we can actually learn about a couple things. First, be careful. You are highly likely to get a complaint if you parody somebody else. And if you're not on board with getting a complaint, then you probably don't want to do it. Just think about it. If it was your property and somebody used it in an ad, even in a parody sense, would that be something that you would want them to do and not complain about? Probably not. Number two, research the property owner. Now, in this instance, Adam Yauch, who's one of the Beastie Boys, was purportedly had in his will that he was against any of his songs being used for a commercial purpose. Now, is that binding on the court in this particular case? No, but it certainly goes to the PR value of how people perceived the Beastie Boy usage, which could have ultimately seeped into the case. Now, as we talked about, ads face an uphill battle. So if you are going to do an ad that parodies something else, realize you're starting on the bottom here, and you really got to get over that hurdle if you're going to win the case. And remember that you can't just use somebody else's work because it's cool or fun or funny or you have a good idea. You really have to comment or criticize on the original work in a way that it transforms the original work into something totally new. Now, if you're going to take this risk, make sure that all the key stakeholders have signed off on the risk. You don't want your boss to be mad at you later. You don't want business affairs to say, what the heck were you doing? And you certainly don't want, if you're an agency, your client to have not understood that there was significant risk before moving forward with this type of usage. Now, I know we're all saying, hey, Goldiblox got a ton of publicity. It was totally worth the risk for them. Well, it might have been worth it for them, but I guarantee you that most of you aren't going to get the kind of publicity that Goldiblox got. They got a 1 in a million opportunity, and they got a 1 in a million situation with tons of publicity. So what might have been worth it for them, they may very well not be worth it for you. And finally, right or wrong, we see in that instance, Goldiblox, one of the reasons why they probably pulled out of the case is because legal battles are hugely expensive. And even if you are right, you're going to spend a lot of money defending yourself that you could spend on your own marketing. And you're going to take up a lot of your time, which could be better spent running your business. So you have to take all those points in consideration before you want to jump in that pool and try to parody somebody else's work for your advertising. So you can follow me on Twitter at Bry Heidelberger, or for more mini advertising law lessons, go to youtube.com/adage or youtube.com/Brian Heidelberger. And until next time, let's be careful out there. This hides my double chin, right?